Well, in his defence, following his no-show at the state capture inquiry today, the former president, Jacob Zuma, says he's awaiting the outcome of his review application for the recusal of the chair, the Deputy Chief Justice Raymond Zondo. We're joined now by the legal expert Mototsi Ratchambalani, the founding director of TGR Attorneys. Mototsi, good afternoon to you. There's so many different questions to ask here, but let me just start with this. The Deputy Chief Justice Raymond Zondo now essentially kicking this to the Constitutional Court. It was your order, you make a decision about what happens next. Is that the right thing for him to do?
Look, we are into new territory here, Stephen, but you will recall that earlier the Commission sought direct access to the Constitutional Court, and the Constitutional Court, gave them some tongue lashing, but they did give an order that the former president must appear in court. Now, that being the case, that stands as the order of the Apex Court, and the former president has now confirmed that he will not be honoring that, which means that he will be in contempt of that order. This is not to be confused with the contempt that's contemplated in the Commission's Act and in the Commission's rules. But this, the Concord having made an order, and him having not ordered it, is in contempt of the highest court's order.
So in other words, it's actually the Constitutional Court's problem because it's their order.
Indeed. It is now the Constitutional Court's problem in a way, because they've ordered him to appear, they've ordered him to honor the summonses that are legally issued, and he has not done so. And I think if I can just hasten to say, traditionally in our law, contempt of court was treated primarily as a criminal offense. So in other words, if you make noise in court or you don't show up in court, you will be charged and you'll be convicted for an offense. But over the years, this contempt of court has taken a civil form, and this was occasioned by examples where, for example, municipalities and other organs of state would fail to honor orders of court, and the people who would have brought them to court in the first place, in other words, the core litigants, will bring an application to court for the court to order that those government entities are in contempt. And, without boring with the legal technicalities, that has led to a situation where contempt of court is no longer a criminal of a sort of process per se, but it's got a civil element to it where there will be the contesting parties would, seek a remedy for contempt of court, which I suspect that's what the Deputy Chief Justice is talking about, that they will go to court as an affected person seeking that an order of contempt be made against the former president. And I suppose on the same breath also venture out, what will be the appropriate sentence in the circumstances.
So then Zuma's lawyers argue, and they put it in their statement today that they released prior to his non-appearance at the Zondo Commission, in which they said that because the former president has asked a high court to order Judge Zondo to recuse himself, because that application has not been heard, that's why he didn't appear. But are you suggesting then that it really all hinges actually not on that application, not on the Zondo Commission, but on the Constitutional Court order?
Indeed, Stevens, I think that question was answered in the arguments that were made in the recusal application, and I think there's enough case law to suggest that the fact that he refused to recuse himself and that is still under review, does not seem to support the fact that he can then use that as the basis on which not to appear before court. Obviously, that's an argument that they will make, but case law as it stands, I think it's stacked against them. But judges are there to be convinced. If they make a case to support to the contrary, they might get away with it. But in my respectful view, at this moment, it looks an unlikely argument.
There's this continued claim by Zuma's supporters, Carl Niehaus, Kabima Patswe, others, that his right to silence or to not incriminate himself is being infringed here. Now, as I understand it, this is because he's being asked to testify as a witness and not as an accused. How important is that distinction?
Look, I mean, it's quite an important distinction, and the Constitutional Court re-emphasized it in its judgment. It seems to have been lost, with some of the witnesses that have appeared before the commission. But the law as it stands and as confirmed by the Constitutional Court is that, I think people are conflating the right to silence and the privilege against self-incrimination. Now, the privilege against self-incrimination, it's what witnesses have. They do not have a right to silence. So simply put, the right to silence is afforded to accused persons. If you are caught by the police and you are under arrest, and they want you to make a statement, you have a right to remain silent. That's the equivalent of the Fifth Amendment in the United States. Witnesses who appear before courts or any tribunal, such as the commission, they have a right, they have a privilege not to against self-incrimination, but that's not a blanket right. The adjudicator, in this case, the chairperson, will have to make a call whether or not you've made a good case not to answer for fear of incriminating yourself. So there's that nuance. The one is an absolute right to be silent, in which they will absolutely say, I'm an accused person here, my constitutional right, I remain silent. Whatever you inferences you make in my out of my silence, it's your call. That's not what's available to witnesses in criminal cases and in tribunals such as the commission. There you have the right, the privilege not to incriminate yourself, but it's not absolute. It's dependent on whether or not you've made out a compelling argument to that effect.
Okay, let me use a slightly uncomfortable example. So if, for example, I stole a cell phone, I would have the right not to testify in the case against me. But if my friend Kathy Mokgokgana saw me steal the cell phone, she would not have a right not to testify. She would have to testify that she steal the cell phone.
She certainly has to testify, but if she's asked a question which potentially links her to your stealing the cell phone, she may then say, I invoke my privilege not to incriminate myself. But she cannot say, as opposed to you, who can say, I'm the accused here, I absolutely choose to say nothing at all. That's the difference.
I'm sure she's going to have a word with me after the show. Matotsi, how long could all of this take? Now, I say this because there's a city in Russia that always ends up coming up in our conversations around the law in this country. I never kind of understand where it comes from. But could all of this actually take quite a long time?
Look, potentially, you will recall that when the commission approached the Constitutional Court, one of their key arguments of agency and direct access to the court was that the commission's lifespan was coming to an end. They are running out of time. And therefore, they decided to approach the apex court to make a semi-agent, ruling. I think now that the charge of contempt against the former president, it might be important to them, but it's not agents in the legal sense. So I think they will be hard-pressed to go before the court and say, leave everything else that you're doing. We have this case of contempt here, please hear us out. Because if you think about it, even if they were to go 2-3 months from now, nothing much changes. The evidence is on paper. So I think it can be, the Constitutional Court is quite efficient. It runs its role quite effectively. But the only thing I can say on this one is that I do not think the commission will have the luxury of agency that they had, in the earlier approach to the Constitutional Court.
Matotsi Ratchambalani, thank you very much indeed. Founding Director of TGR Attorneys. Really appreciate the time and the explanation tonight.